So this is the situation we have before us. Miss Clementina Obilile, a woman of African descent, came to this country over 20 years ago and contributed significantly to the health industry. She took up employment with the defendant in May last year, and by February of this year she had to resign as a direct result of the treatment she had. Now, we asked the tribunal to find that Ms. Obilile was the recipient of unlawful discrimination. And we asked you to arrive at that conclusion on the basis of the following. Firstly, Mrs. Burton did not allow Ms. Obilile to properly air her views and concerns on matters relative to the cleanliness of the heroin ward. The first time she attempted to do so, Ms. Burton thanked her for the input, but went on to say to her, firstly to suggest to her, why don't you retire? But not why don't you retire and go to enjoy your golden years. It was why don't you retire and go back to Malawi? What do we know about Malawi? It's an African nation and its indigenous population is black. And that represents the racial undertone, the commencement of what was about to happen to Ms. Obilile. Ms. Obilile was not allowed respectfully to contribute to ward meetings, and whenever she made a contribution, it was met with scorn and indignation. On the other hand, Mrs. Rose Michaels was allowed to participate in meetings, to make her suggestions, and whenever she had queries, they were responded to quite respectfully. What inference can be drawn from such a treatment? The need is for the tribunal to have an objective as opposed to a subjective evaluation of the overall circumstance. And we can look to the witness statement of Ms. Rose Michaels for that objectivity. In paragraphs 2 and 4 of her statement, she points out a number of circumstances where Ms. Obilile was constantly at the receiving end of discriminatory attacks from Ms. Burton. And so the question becomes, what must account for this? They're both women, they're both senior nurses. One was listened to and responded to respectfully. The other was not listened to or not responded to respectfully. What's the difference between them? One is black, the other is not. It is important to note in paragraph 6 of my submission, I addressed the issue of the shift system. That Ms. Burton used the shift system as a means of further discriminating against Mrs. Obilile. And it cannot be accounted to anything else. When Mrs. Burton draws up a rota as to how Mrs. Obilile is expected to work and places her on a shift pattern that no other member of staff was placed on ever, then that says to us that she was being treated less favorably when compared to her other colleagues. She was the only one who was asked to work on such shift pattern. And Miss Amy Winters of the Personnel Directorate of the Trust summed it all up by describing that shift pattern as being inappropriate. In essence, what Miss Winters is saying here is that it was wrong, it was unwanted, and it was ridiculous, to say the least. And so the Trust cannot justify that treatment which Ms. Burton handed down to Ms. Obilile. It is crucial to note also that Ms. Burton listened to Joy Sutherland, an auxiliary nurse on the ward. An auxiliary nurse got the ears of the ward manager, but a senior practitioner, a senior nurse of over 20 years experience, simply could not get the ears of the ward manager. The Trust, we submit, became equally guilty in the discriminatory act when it did not follow its own grievance procedure to give ear to the concerns of Ms. Obilile. And we asked the court, the tribunal that is, to consider the matter in Coiney and Home Office 2000, the Industrial Relations Law Review matter on page 238. It was wrong for the Trust not to have used the procedure, and simply to have written off her concern as a personality clash. We asked the tribunal also to find that Mrs. Obilai was unlawfully harassed by her employers. Ms. Obilai's perception of how she was treated is not what is important here. It is how reasonable was that conduct. We would see in paragraph 10 of my submission that the Equality Act of 2010 says that a person harasses another if he engages in an unwanted conduct which has the purpose or the effect of violating that other person's dignity or creating an intimidating, hostile, degrading, or humiliating environment within which that person must function. Clearly, the evidence that is stacked before us shows that Mrs. Obilai was treated in a degrading fashion, a hostile fashion, an intimidating fashion, in a humiliating fashion, and as such her environment became very, very offensive. When she first suggested the cleaning issue on the wall, she was told, yeah, thanks for your suggestion, but guess what? It's none of your business, not your place. The medical expert, Miss Santiago, concluded that the only reason that Miss Obilai was going through what she's going through is as a direct result of the treatment she's been having on the ward. The use of the shift system to harass Miss Obilai was clear. Mrs. Amy Winters said that that shift system that was used to harass Miss Obilai was wholly inappropriate. And so we asked the tribunal to consider the matter in situ cleaning company limited and hence 1995, a matter heard in the employment appeal tribunal and reported at in the 4th volume of the industrial relation law review. I turn to the matter of Mr. Cedric and the blame that was apportioned to Ms. Obilai. It is our conclusion that apportioning of blame was simply used as a cover to further harass Ms. Obilai. I mean, all the evidence between paragraphs 11 and 16 of my submission will point clearly to that particular matter. It all came to a very unfortunate situation on the 9th of January 2012 when Ms. Burton could not control herself anymore and she virtually reduced Ms. Obilai to emotional wreckage in the presence of her other staff members. And again, paragraph 19 of my submission would capture in essence the rest of that argument. The tribunal must not accept any suggestion or submission from the trust that it has reasonable step defense. And I say this for the following reasons. Whereas it is accepted that both Ms. Obilai and Ms. Burton knew that the trust has a policy in place for anti-harassment and anti-bullying, the trust itself failed in following the grievance procedures, and as such it disallowed itself the possibility of that defense. And we asked the tribunal to consider the matter in Caspers and the Ministry of Defense that was heard in July of 2005, a matter in the Employment Tribunal. We further advanced that the trust is liable for what happened to Ms. Obilai, in that the principle of vicarious liability must apply. Ms. Burton was acting in the course of her employment when she treated Ms. Obilai to the plate full of unlawful discrimination and a pot full of unlawful harassment. And the matter in Canadian Pacific Railway and Lockhart 1942, a matter heard in the appeal court and reported on page 592 of that report, would point to that very clearly. We submit that clearly it is the responsibility, and I've developed on it for that at paragraph 22, that the burden of proof rests solely on the trust to show that the treatment was not unlawful discrimination or not discriminatory at all, and I submit that it will be difficult for them to do so. On the matter of limitation, it is suggested that the issues raised in October of 2011 may well be shared to be out of limitation, but we submit that the others are well within limitation, those between November 2011 and February 2012. And even if the one in October happens to be out of limitation, it represents a continuing act of discrimination on the part of the trust, and we ask the tribunal to take it into consideration. On the matter of compensation, we say that Mrs. Obilai should be awarded the various issues for the various matters that she has raised in her request for compensation. The £157 that she lost as a result of the shift pattern, we already heard Ms. Amy Winters' inappropriate shift pattern. If it hadn't been for that shift pattern, she would not have lost £157. She should get it back. £3,315 for that loss that she encountered between the grievance procedure and the time of the hearing. We asked the court, the tribunal, to award her that too, and to be instructed by the matter indictment and Brent, London Borough Council, 1987, a Court of Appeal decision, but came from and reported in the Industrial Relation Law Review at page 146. That is instructive. Because of the flawed procedure, she is entitled. Her medical expenses clearly flowed from the treatment that she had, and I don't think we should engage in much argument on that matter. Her future wage loss, a woman at age 55, her self-confidence damage, her resignation flowed from that treatment. I mean, all of it is clear and obvious that Mrs. Obilai ought to receive that compensation for her future wage loss. I mean, ask the tribunal to consider the matter in Vento and Chief Constable of West Yorkshire Police, 2002, a matter heard in the England and Wales Court of Appeal, Civil Division, and reported at page 1871. The question as to whether or not Ms. Obilai could have gone for alternative employment, that matter is tied to the circumstances that I raised above. And in that regard, I ask the tribunal again to consider the matter in London and South England Building Society versus Stone, 1983, All England Report matter at page 105. The burden, the significant burden, is on the trust alone to show that Ms. Obilai was unreasonable in not having sought additional employment based on what I've said above. Her age, her self-confidence destroyed, all of it on the backs of the NHS Trust at Westmoreland Healthcare. And in closing, I'd ask the tribunal that there be a recommendation that the Trust engage its ward managers in serious training addressing the matters of equality and diversity. At any cost, both parties can benefit. The ward managers themselves and the Trust as an institution offering a service to healthcare persons. There's no loss that could be had from it. And in closing this submission, we say that whilst financially the losses of Ms. Obilai can be met, those do not represent all the losses that she has suffered. That loss to her self-confidence, that shock to her self-esteem still remains in the wide open. And we ask the tribunal to demand that the Westmoreland Healthcare NHS Trust and Ms. Celia Burton officially tender an apology to Ms. Clementina Obilai for the treatment that she had to undergo during her time in employment with Westmoreland Healthcare NHS Trust. Sir, this is my submission in essence, and I rely further on the submission, my closing submission that I make with this written submission, that is, with this my oral presentation. unless I can be any further assistance to you.